we've all read, as we were instructed to, the paragraphs of the skeleton argument, and we think that, subject to any questions by the court, that 15 minutes should probably do. But obviously, if that overruns, then we'll see.
Yes, May, I'll do my best, and I'm conscious of not encroaching onto Sir James's time. What we've agreed is that this time will come out of our reply tomorrow.
Well, that seems very fair, so good.
As the court will realise, I'm very grateful to you also for reading the skeleton. Thank you very much. As the court will have understood, on ground 4 of the ECHR appeal, the essential point is that the scope of application of Part 7, read with the underlying powers of MI5, MI6 and GCHQ if necessary, is so wide, and its provisions as to retention, use, destruction, so discretionary, that it does not satisfy the requirements for foreseeability of state databases. And I take as read for this purpose the Divisional Court's summary of Part 7. For your note, it's paragraphs 210 to 221 of the 2019 judgment. I will address this point in 3 stages. I'll first make good the proposition of paragraph 45 of our skeleton that substantially similar principles apply to state databases as apply to state surveillance regimes. That's MARPA. Then I will show you one case where those principles were applied, leading to a finding that a regime was not in accordance with the law. That's MM. And then I will apply those principles to Part 7 briefly. As to the judgment below, you have the points for making the skeleton. I can't do better than that orally. So first, if we could go to MARPA, that's Authorities 237, page 1332. That case concerned the UK's regime for the retention of fingerprints or DNA samples, and specifically provision for their retention after the purpose for which they were initially taken. They were permitted to be retained for the prevention and detection of crime and similar purposes. The key point I take from it is that at paragraph 99, that is the statement of principle as to the requirements that apply for a state database. And the simple point is that is substantially the same as the secret surveillance regime principles, and you see that from the footnote 57. All of those cases cited in that footnote are indeed state surveillance regime cases. And I believe that is effectively common ground. I say that by reference to paragraph 62 of the respondent's skeleton for your notes. That's core 1 for page 106. As is apparent from this paragraph, MARPA does not resolve on the question of in accordance with the law. The court goes on to resolve the case on the basis that the regime was disproportionate. But what I do want to show you, therefore, it's relevant for the principle, but not an example of its application. So what I do want to show you is MM. That's Authorities Volume 2, tab 42. The page I'll start on is 1521. That case, Volume 2, tab 42, page 1521.
Yes.
That case concerned the retention and disclosure of information relating to criminal convictions, cautions, and other criminal records in Northern Ireland. And as we'll see, the court ultimately concludes that the regime was not in accordance with the law because the powers to collect and disclose that information were very broadly and vaguely defined, and the safeguards were ultimately insufficient. Could I ask you to look first at paragraph 195? That is the key statement of principle. And the bit that continues over the page is quite important in my submission. That at at each stage appropriate and adequate safeguards which reflect the principles elaborated in applicable data protection instruments and prevent arbitrary and disproportionate interference with Article 8 rights must be in place. The point Mr. Jaffe was making yesterday by reference to this being a quality of law requirement, it not being enough to trust the Secretary of State and Judicial Commissioner will act proportionately in all the circumstances. And if I could ask you to then read through the court's analysis, it really starts at paragraph 198 on 1522. The court first addresses the power to collect, retain and disclose the information, notes that it's a broad policing, common law policing power. And then 199, particularly at the end, you see where you've got indiscriminate, open-ended collection of data that's unlikely to comply with Article 8 in the absence of clear and detailed statutory regulations, etc. Then 200, a critical point. The greater the scope of the recording system and thus the greater the amount and sensitivity of data held and available for disclosure, the more important the content of the safeguards to be applied at the various crucial stages in the subsequent processing of data. The broader your regime, the better, tighter your safeguards must be. And you see then from 202 onwards, the court's analysis of the particular regime in question. 202 to 203, the court explains, as I mentioned, it's a broad common law policing power subject to the Data Protection Act. There's some guidance, it provides for a 6-year review of retention. 203 looks at disclosure of conviction information, again pursuant to the same broad power. The policy requires proportionality and a balancing exercise, but it doesn't describe specific factors. 204, there was a change to the regime for disclosure. That's explained at 204 and 205. And then you see at 206, 207, the conclusion. The cumulative effect, that there were not sufficient safeguards in the system for retention and disclosure of criminal record data, etc. So having regard to the broad scope of the power and such safeguards as there were, this is not sufficiently constrained. Applying those principles then to Part 7, we make really two simple points. First, the scope of Part 7 is very wide indeed. You saw section 199 of Mr. Jaffe yesterday in the discussion about the kinds of information it might hold. My submission, it is really difficult to imagine any kind of digital data that, once assembled, would not fall within the scope of that regime. It is extraordinarily broad. And then one looks, on the other hand, at what safeguards there are. And our submission there, as you will have seen, Part 7 lacks many of the important safeguards, including by comparison to the Part 6, in particular Chapter 1 and Chapter 3 powers, that's bulk intercept, bulk equipment interference. While it can be said that there are lots of requirements to consider putting safeguards in place or requirements to have requirements, in terms of actual outcomes required, the Act and the Code of Practice are thin. I'd emphasise 2 points in that regard. First of all, as we say in our skeleton, there are no mandatory requirements for deletion of bulk personal data sets or information extracted from them, and mandatory requirements to minimise the disclosure and copying of information of the kind that exist in Part 6, Chapter 1 and Chapter 3. And my friends refer in response to this to various paragraphs of the Code of Practice. None of them contains equivalent requirements to section 150 of the Act. The second point I would emphasise is the absence of any British Islands safeguard, which we discussed yesterday. So that is where you are selecting content using a criterion referable to an individual who is known to be in the British Islands for the purposes of selecting their data. You want theirs. then you must go and get a targeted examination warrant under Part 6, Chapter 1, bulk intercept, or Part 6, Chapter 3, equipment interference. No equivalent regime under Part 7. The best you get is Section 207, that's Authorities Volume 4, tab 67, page 2857. And what you see is the Secretary of State may impose criterion if she sees fit. As I said, in relation to errors below, we rely on the skeleton. And then, unless there are questions on that, I turn to address the privilege points, which I'll do quite shortly, and I won't attempt to go through all the breaches. That's all right, because ultimately that can be dealt with once the court's decision on principle is known. The submission here is that on such Strasbourg authority as there is, and by analogy to the position of journalists, the protections which apply to lawyer-client communications are essentially the same. There must be prior independent authorization of a search of those communications. There must be particular weight, or an overriding requirement, however expressed, given to the importance of their confidentiality in the proportionality analysis. And where you come across them, as it were, in what you're looking at, where it's not your purpose to select them or it's not likely, then you must stop and apply those safeguards to further use of the information. If I may, I'll make 3 points, and I hope to be less than the 5 minutes I've got left. The first is to look at the rationale for the protection of lawyers and why we therefore draw the analogy to journalists. The second is to look at the 2 cases that directly address secret surveillance of lawyers. And the third is to address briefly some points made against us. I should make clear as well, we of course accept that the Act includes some safeguards, and indeed some of them are strong, but we say it doesn't meet the standards that I've articulated across the board. The court will have seen the extract from Assured set out in our skeleton. It's at paragraph 53.1. It may be useful to have that open. It's core 1, tab 3, page 58. Simply the court's recognition of the strength and protection accorded to lawyer-client communications. And our submission is, you take from this that the rationale for the protection of lawyers and journalists' material is extremely similar. Lawyers play a critical role in a functioning democracy, and they can only play that role if there is societal confidence that their communications with clients are indeed confidential. Position is not materially different from that of journalists. And it follows, we say, by analogy, that the safeguards identified in Big Brother Watch apply also in relation to lawyers. And the second point is what cases there have been. We do say that there is direct support for this, at least to a point, in 2 decisions. The first is that in Cotland, Switzerland, that's Authorities to tab 28. I'll take it from page 1082. Here, this was a case very early on in the development of these principles where the phone lines of a law firm were tapped. And the court ultimately concludes that Swiss laws in question were not in accordance with the law. Could I ask you to look first at, I'm so sorry, could I ask you to go back to 1080 and read paragraph 64?
1080.
1080.
Got it, thank you.
The general principle in what are now familiar terms since developed in Big Brother Watch, of course. And then I think it suffices to really read from 72 onwards on 1081. If I could just invite the court to do that through to 75 where you get the conclusion. key points are at 72, you see recognition that independent authorisation is an important safeguard. And then you see what was wrong in 73 and 74 with the particular Swiss regime in question, because of course in COP there was the independent authorisation. And what's critical is to see how COP has then been subsequently understood, and you see that from Szabo. I can take that from our skeleton, page 59 of the core bundle. Szabo is a case about the Hungarian surveillance regime, so a secret surveillance case applying principles developed in Big Brother Watch. And in my submission, the extract from paragraph 77 set out in our skeleton expressly states that ex ante authorization in the circumstances of COP, i.e. telephone tapping of lawyer-client communications, is required, and it expressly draws the analogy I invite you to draw with the principles applicable to journalists. Now, you might say it's brief, you might say the case wasn't specifically considering lawyer-client communications, but it is a statement directly on point, directly in support of us. What do the respondents have going the other way? Answer, nothing. And in fact, in their skeleton, they say Szabo does no more than purport to summarise the principles from cases including COP. We agree with that entirely. It summarises them correctly. So we say on the question of independent authorisation, that does support our case, and the judgment below 2019 judgment paragraph 287 refers to Szabo, but without reference to this paragraph asserts, and without explanation, that it supports the view that Strasbourg jurisprudence does not lay down a requirement for prior independent authorisation. That is simply incorrect in light of this passage. So that's sufficient for us on the question of prior independent authorisation. Otherwise, we rely on the analogy I've explained. But may I, in 2 minutes, address the points made against me? The first is that it's said in paragraph 65 of the respondent skeleton that lawyer-client communications were, quote, squarely before the Strasbourg court. That is incorrect. It is right, as they say, that 2 interveners filed submissions addressing legal professional privilege. The parties' submissions did not address the point at all, as you see from the summary of argument. For your note, it's paragraphs 277 to 299.
When you say in Strasbourg, you mean Big Brother Watch?
Yes.
That was the Law Society was one.
The Law Society was one, that's right. But the parties didn't raise it, milady, and the reason is it wasn't raised in the IPT below. So we didn't feel, Mr. Jaffe and I appeared in that case for the 10 NGOs. We didn't feel we could raise it at that stage, it not having been a live issue at all in the case. But it's, the absence of reference to this in Big Brother Watch is in my submission of no significance in those circumstances. And what's also said against us is that RE, that's authorities 2 tab 47, I don't need you to turn it up, somehow suggests that independent authorisation is not required. In that case, the regime required independent authorisation. So we don't see how RE helps. If some submission is made, then we'll deal with it in reply. Those are my submissions. May it please the court.
Thank you very much. Yes. Sir James.
My lady, my lord, I'm not going to repeat all of the important analysis undertaken by the Divisional Court in their ECHR judgment, which I'm sure you will all have read, which you find behind tab 30 in the core bundle, page 890 and following. But we do invite you to go back, as it were, as the starting point to that judgment, because it contains some pretty important matters of context which can be lost when we focus in, as we now do in this appeal, after endless rounds of litigation, to a succession of kind of narrow and discrete and rather complex points. The context which I have particularly in mind is the context described at paragraphs 18 to 33 of the Divisional Court's judgment in the ECHR case, which sets out in some detail both the threat picture that led to these powers being, as it were, pulled together and examined again by Parliament. That's the context in which this legislation is made, with the enormous importance of the powers that you're considering in terms of public protection, and also the degree to which those powers were subject to pre-legislative and parliamentary scrutiny. So for the context, see in particular, if you would, for your note, 18 to 33, which sets it out generally, and they then return to the importance and the threat context at 158 to 159, and in relation to CD, that's communications data, at 245, and you have Mr. Dix's statement on which most of the threat picture was based. You've been taken to it a couple of times in the supplementary bundle if you want it in the raw, but all that you really need is summarised in those paragraphs of the Divisional Court ECHR judgment. There's also in that judgment a very, very helpful summary of the scheme of the IPA generally. Again, it's difficult jumping into an act of this complexity at isolated points and then assuming that you understand how it all hangs together generally. But there's a helpful summary of the scheme and the core common safeguards, a matter of obvious importance because quite a lot of it replicates the degree of safeguarding as you go through. Again, in that judgment, just to have it to hand so you see the bits as it were, but if you go to tab 29 in the core bundle, page 850, the judgment starts. The bit I have in mind for this purpose starts at paragraph 34.
I think you've given us the EU.
I've given you the wrong reference.
Yeah,
902.
tab 30, I think.
902 behind tab 30, sorry. There should be a heading saying the legislative scheme.
Yeah.
That's the one. And from there through to the end of 62, which is on page 906, you've got a very, very helpful, or at least I hope it's very helpful, a very helpful summary of common safeguards, structure of the Act, how it all hangs together in overview. And of course that section is itself a summary of the agreed document, or jolly nearly agreed document, that they chose to, that the Divisional Court chose to annex to their judgment, which contains a bit more description of all the component parts of the legislative scheme, starting on page 972. So if you wanted the overview, and we respectfully submit you need to have it in mind as to how it all works, then that's where you get it. And the reason that I emphasise that the importance of that overview is not really to put you into the picture for what comes by way of individual challenges, but also because it tees up and emphasises a point on which the Divisional Court in their ECHR judgment placed considerable emphasis, which is the need to take into account at each stage and in relation to each challenge to specific parts of the safeguarding scheme, you need to take into account what they described as the totality of the interlocking safeguards. See paragraph 160 of that judgment. And they included, deliberately and specifically at various points in their judgment, they included within that set of interlocking safeguards, properly reflecting the Strasbourg case law, that was the right approach, the oversight powers, including the oversight by IPCO, the Commissioner, the day-to-day oversight things, the auditing of records, the dipping in and out of the agency's offices for the purpose of checking that the powers are being applied correctly and all of that, a very important part of the scheme, and also the powers and jurisdiction of the IPT, the Investigatory Powers Tribunal, which was dealt with by the Divisional Court at 169 to 170 of their ECHR judgment. And again, they were entirely right, obviously, to take into account those features, as one sees, just to give you one other reference, just by way of example, into BBW Grand Chamber. See for that purpose paragraph 349 of BBW Grand Chamber at page 2299. which emphasises the importance and the considerable reliance placed by the Grand Chamber on those oversight features, even in relation to the regime as it was under Ripper. The Divisional Court in their ECHR judgment also expressed at least a degree of caution before directly transposing the findings of the European Court of Human Rights in BBW. Of course, then it was the first section rather than the Grand Chamber, but the note of caution inures, given that that set of findings was related to a different set of legislative provisions, those in Ripper, and as the Divisional Court pointed out in their ECHR judgment, see paragraph 161, there are new structures, entirely new features, including particularly the Judicial Commissioner double lock process in the new IPA. So just to pick up their essential conclusions, if I can summarise them in 4 or 5 points, they firstly, that's the Divisional Court in their ECHR judgment, firstly concluded that it was a key general principle, as they put it, I've given you the reference already to 160, that the question of compatibility with the ECHR must be determined by reference to the totality of those interlocking safeguards. 160 in their judgment reflected in the Grand Chamber, subsequently in BBW, at 360, emphasising the need for, as they put it there, a global assessment. Global is the adjective used by the Grand Chamber when assessing compatibility. Secondly, applying that approach, the Divisional Court concluded that the IPA set out the bounds of the exercise of power with sufficient clarity and precision to conform to the in accordance with law requirement. And it did so having regard to the specific interlocking and powerful controls, including, go back to their overview in those paragraphs I gave you earlier, 34 to 62, including warrants being subject to Secretary of State approval, and then the Judicial Commissioner double lock, necessity and proportionality built into the scheme, operational purposes built into the scheme for the purpose of the bulk powers in Part 6, including in relation both to the acquisition of data and in relation to the examination or the selection for examination of the resulting data so captured, and having regard to the oversight powers that I mentioned already of the Investigatory Powers Commissioner, Sir Adrian Fulford at the time, now Sir Brian Leveson, and the jurisdiction of the IPT, now I think under the presidency of Lord Justice Edis, previously Lord Justice Singh.
Still Lord Justice Singh.
Still Lord Justice Singh. I'm sorry, I didn't mean less Majesty. Maybe I'm predicting too much on behalf of Lord Justice Edis, but anyway, but senior Courts of Appeal judges, as you know. And they concluded that all of that was plenty sufficient to conform to the basic principle of in accordance with law. And those conclusions were upheld in their essentials by the European Court of Human Rights, subject to the specific points that you know about, where the government has made concessions as a result of the Grand Chamber judgment, which largely reflected the section judgment. There were some points of difference and nuance between them, but the essential approach and conclusions were very, very similar. But essentially upholding the Divisional Court approach. And it's, I think, fair to point out that by the time the case gets to the Grand Chamber, and I think in the section as well, the European Court of Human Rights is well aware that it's dealing with Ripper. That's the specific set of issues that are before it, but it also knows that the IPA is on the stocks. They had the IPA there, and it seems not unnatural that when they were considering particular aspects. They looked at RIPA, and then they had a weather eye, at least, to the fact that there was new legislation governing the points. And you can see some echoes of the things that weren't in RIPA that are now in the IPA bouncing around in the judgments that the European Court produced. So those essential structures are essentially upheld, even in the context of RIPA. And of course, the point that follows from that is that the position in relation to the IPA is a fortiori, because of all the additional features and the additional detail that the IPA brings to this subject. There is a reason that it extends to how many sections it extends to. It followed on from the set of proposals that said, principally from Lord Anderson, that said you need to pull all together these disparate powers into one piece of legislation. And there was an obvious and conscious attempt to try and bring in the safeguards that would be sufficient both for ECHR and EU law purposes, and that has led to a large and complex set of safeguards. But the full point is that the protections in the IPA are considerably more extensive, much more detailed than they were under RIPA. You will also note that by the time the case came back to the Divisional Court in 2022, they analysed both EU law and to some extent also analysed, and they had before them, the Grand Chamber judgment in BBW. And one sees a reflection of that, for example, in paragraph 140 to 142 of the 2022 judgment of the Divisional Court behind tab 31 in the core bundle, page 1029. I wanted to pick up, if I may, by way of these introductory submissions, 2 points on the approach that the court, the domestic court, needs to bring to bear on when a challenge is made to legislation of this kind, or perhaps 3 short points in relation to that. The first of them is reflected in the Divisional Court's judgment, its ECHR judgment, so it's tab 30 of the core bundle, page 910, if you would. And the paragraphs I wanted for this purpose are paragraphs 83 to 89. Again, I'm not going to invite you to read it all now, but just to set the scene in relation to this. What is being dealt with in these paragraphs is the correct approach to the concept of in accordance with law. And the reason that the court went out of its way in these paragraphs to deal with that issue is because it is fair to say that there was something of a muddle at the highest level as to where the dividing line lay between a challenge that went to in accordance with law, where the right answer is binary, it is in accordance with law or it isn't, and a challenge based on proportionality, particularly when you're challenging the proportionality of a particular provision in legislation as opposed to its mere application, which I'm going to come on to. But the reason that the Divisional Court were interested in that issue is obvious, because the in accordance with law thing was the principal basis on which that was challenged. That had been the subject of previous Supreme Court cases on the context of revealing people's criminal convictions and cautions in a case called T. You don't need to go there. But the confusion had in large part centred on the MM case, to which Mr. Heaton took you shortly after the short adjournment. And what Lord Sumption did in, what Lord Culmworth and Hughes and then Lord Sumption did in the P case that is cited in paragraph 83 and following of the Divisional Court's judgment here, 910, is in effect a clarification of the right approach. And you see in particular the quotations from the judgment of Lord Sumption, in P and the Secretary of State for Justice, effectively on that point of distinction. What does in accordance with law bring by way of challenge, and where is the boundary between that and challenging a legislative provision, and so on. And so those paragraphs are important because they represent the current and correct state of the law from the Supreme Court on where that dividing line truly lies. And so one needs to be a little cautious, or perhaps more than a little cautious, with both MM and indeed MAPA, where it looks for all the world as if they're doing it in accordance with law analysis, and then it comes out as proportionality. But leave that on one side. This is the correct statement of how those dividing lines work. That's the first point in relation to approach. The second point in relation to approach will be very familiar to the court indeed, so I can take it much more crisply, and that is to emphasise a couple of points arising out of the Supreme Court's more recent judgment in the AB case. That is in the authorities bundle behind tab 10 at page 362. And the reason I want it, sorry to give you an immediate next page reference, if you go to 386 in the electronic bundles, that should get you there. And I hope that you will see the relevant section that I want highlighted, as in sideline, page 386, paragraphs 56 and following. Right. My learned friend Mr. Jaffe took you to this yesterday for the purpose of a submission based on paragraph 59 that said if the Strasbourg case law is clear in its establishment of the principles and the approach, then you apply it. And if that involves a little bit of incremental development, well, so be it. That's the thrust of paragraph 59. AB, however, didn't just say that. It dealt with the contrast, as it were, and where that position, described in paragraph 59, starts. And that is the subject of the analysis in the paragraphs that preceded, 56 and in particular 57, with the citation of the authority that supports the proposition in 57 at 58. So the passage I really want, because it's a summary of it, this is about ULA. This is about what you do when it's not entirely clear what Strasbourg is going to do. Do you leave it here? Do you jump yourselves? How far do you go if you're going to jump? And all of that. It's all about that. And there had been some controversy about how ULA worked, no more, no less, and the debate that surrounded that. But the place at which the Supreme Court has ended up, and the reason I emphasise paragraph 57 is because they applied exactly that approach and exactly the phrase I'm going to alight on in a case which happened very shortly after AB, which was the X in the passports case, Elan Kane, that was called. But as you see, you can tell when they're designing a test because they use the phraseology twice. And the phraseology they use is fully confident. Can the domestic court be fully confident that Strasbourg will go to the place to which the claimants invite you? And unless you can, is the reasoning of the Supreme Court here then applied in Elan Kane and ever after, unless you can, the correct constitutional approach under the HRA is to find no incompatibility, because that will enable the government to do what it could not otherwise do, because it would be stopped in its tracks by the domestic court rulings, which is to go and test the arguable point, if I can put it in that way, the non-fully confident point, to go and test that in Strasbourg, where it will be determined by an international court with the broader horizons that international courts of this kind bring to bear on the issue. So that's the AB things. It's a fully confident approach. When you come to the question of whether or not you're going to jump as the claimants or appellants would wish you to do, then that is the approach that you need to be applying. So 57 summarises the test. sorry to hand up a couple of new authorities, if I may, but they're on the approach, and so we thought it was important that you should at least have them. One of them is responsive. I said there were three, there might be four points I was going to make shortly by way of introduction. One of them responds to a point my yeah, one of them responds to a point that my Lord Justice Lewis raised yesterday, so I hope he'll forgive me for that being added to the fourth. Yes. The first one I want is the longer of the two, but I only want a short passage. It's the abortion services case.
Thank you very much.
And you will see its date. And you'll see that it's a 7-person court. And this was about all about putting in place protections in Northern Ireland around abortion clinics for the purpose of safeguarding the rights of women who are interested in those services. The bit I want really is that the reason I'm going to this case is because I want the passage that starts on page in paragraph 13 on page 521, bottom of page 521. Below the letter H, you'll see paragraph 13. Now, that sets out the well-known test delivered by Lord Reid in a joint judgment with Baroness Hale and Lord Hodge in a case called Christian Institute. And what that does is to explain what the correct approach is when you are dealing with challenges to legislation as legislation. And you'll see the height of the hurdle that is put in place if that sort of challenge is to be upheld from the quotation between B and C on page 522 at the end of paragraph 13, and then if you read into paragraph 14 as well, if you would, and then I'll explain what this case is doing. So that explains what the principle is in the quote from Christian Institute and why it exists.
Yes.
And, my lady, the problem that had arisen was that in subsequent Supreme Court cases, it's evident Lord Reid felt, in subsequent Supreme Court cases he hadn't been taken at his word, and that was something that he wished to have sorted out so that people weren't in any doubt about what the test was, and expressed a little surprise given that the departure from what he thought he set out was principally created or in part created in cases in which one of his co-authors had been a member of the court. So the long and the short of all of this is that if and to the extent that there was a difference between the Christian Institute approach and the subsequent case in the Supreme Court, that has been put to rest, that has been laid to rest. And he does so in paragraph 19, having gone through the basis on which there might have been some little confusion in the case law that followed Christian Institute. So it's in effect a reassertion. It's we meant what we said in Christian Institute, punchline in paragraph 19. The fourth point on approach flows from Roberts, which is the shorter of the two new cases I've just handed up. And the reason for going to that was because my Lord Justice Lewis yesterday, I can't remember in the context of what, but said, well, isn't it quite important to take into account the existence as part of the statutory framework of Section 6 of the Human Rights Act when you're judging the adequacy or effectiveness of the safeguards that exist, particularly because, no doubt, Section 6 of the Human Rights Act conditions the way in which discretions that are conferred by legislation on the executive must be exercised. And under Section 6.1 of the HRA, they must be exercised compatibly with convention rights, so that if convention rights have been authoritatively set out in decisions of the Grand Chamber, then those have to be conformed to in the exercise of discretion. This case, Roberts, you'll see the context, stop and search powers without suspicion, and the allegation was, as you see from the head note, that the authority that had been given, no doubt because it wasn't based on reasonable grounds for suspicion or indeed any suspicion, or was arbitrary and so not in accordance with the law. You see that from just by the letter F on page 210 in the head note. That's the essential thrust of the challenge, and the Supreme Court rejects that, concluding that there were lots of safeguards, even though it was a no suspicion stop and search power. And the reason for going here is not to emphasise all of those other safeguards, but to go to paragraph 42, perhaps 28 first of all, 28 and 29, sorry, on page 221. You'll see the first, or just if you just cast an eye down, paragraph 28 and then the first sentence of paragraph 29 on page 221. They return to section 6 of the Human Rights Act at paragraph 42 on page 225 when they come to analyse whether there are sufficient safeguards for this no suspicion stop and search power to be in accordance with the law. And you see what they say in paragraph 42, and then the first sentence of paragraph 43 is perhaps sufficient for our purpose.
Does it make a difference, the invisibility of what goes on for security reasons? Does that make a difference here?
My lady, it can do, and the European Court of Human Rights case law has emphasised that feature, that there need to be sufficient rules that are in the public domain and accessible. But they've recognised throughout the case law, from Class all those years ago onwards, that there are constraints on what you can put into the public domain without undermining the very important nature of the powers that you're dealing with. So my answer is that it can make a difference, but for the purpose of this point, which is whether or not you can rely on Section 6, I submit it doesn't affect that principle. You are entitled to rely upon Section 6 as part of the scheme.
Not just enforceability, it's the constraints on the public body itself. It knows that it is acting unlawfully,
yes,
as well as if an individual sees it, they can stop it.
It knows that, but as importantly, to go back to my lady's question, so does the public. The public knows that Section 6 of the HRA exists, and it knows that the public judgments of Strasbourg say what they say. What they won't know is precisely how the powers have been exercised in particular contexts and so on, but they can't know that because otherwise the powers would unravel. That's why you have all the rules that govern how the Investigatory Powers Tribunal works, and the very broad rules relating to jurisdiction and which people can access on what basis without being met with a plea that they're not victims, though they frequently are. So that's all I wanted to say about the approach to this legislation when the legislation itself is challenged by way of a challenge under the ECHR. I wanted to just emphasise one set of features, or by way of illustration. To some extent it goes back to the overview that the Divisional Court gave of the nature of the powers here, but one illustration as to how the IPA works may be important in relation to these bulk powers, because what my learned friend Mr. Jaffe sought to do was to, as it were, compare and contrast the targeted powers in Part 2, you're going after an individual, with the bulk powers in Part 6 and 7. They're obviously different, and also trying to use examples or isolated bits of the code that concerned things that might well not happen on any view under the structure of the scheme. I wanted just to give you an example of a way that one bit of the Act works, just so you can see those safeguards in operation, as it were. And if one takes bulk interception as the example for that purpose, perhaps. Bulk interception, as you know, and if you want the Act to hand, it may be as well, and you can flick through the statutory provisions if you need it, that the Act starts in 2642 in the authority manual, and bulk interception is dealt with from 2.7 2791 onwards. So 2791 onwards. So just to flick through the features of this, bulk interception is a foreign focused power, and it's a national security focused power. See for that purpose 1381B and 1382. And I emphasise it's a national security focused thing because, as you see, from 1381B, it's either got to be that this is the getting the information in the first place under a bulk interception warrant. A Secretary of State has got to consider that the warrant is necessary in the interest of national security, or that's direct national security, or on that ground and any of the others. So if it's going to be any of the others in sub 2, you'll see is crime and economic well-being. You see that? So the bounce is from 1381B Roman 2 into subsection 2, and you'll see there's serious crime and then economic well-being, but it's got to be that and national security. That's why I say it's a national security focused power, even though it allows those other things, as it were, to come in by way of a side wind. So serious crime on its own would not be enough. It's got to have a national security element. And you will also note that it's only from 1381 first line, it's only the heads of the security and intelligence agencies who can apply for a warrant, as opposed to other law enforcement agencies and others under Part 2, where the people who can apply exist in a much broader cohort. See, for example, Section 18. So you've got top of the office have to make the application, it's got to go to the Secretary of State, it's got to be national security, it's got to be foreign focused. And it's subject to the requirement that you see in 1381D that the Secretary of State at the very initial stage has got to consider not merely the getting of the data, but the examination. He's got to consider that the examination of both content and secondary data is necessary for operational purposes specified in the warrant. So he's got to consider both elements at the initial stage, or she has got to consider both elements at the initial stage. And then under 142, again you saw this yesterday, but it's important to emphasise it because my learned friend Mr. Jaffe underplays, with the greatest respect, the significance of 142 and the safeguards inherent within it, which are new and bespoke, as it were, to this piece of legislation, in large part at least. His focus was on saying, oh, well, all it needs to be is something slightly more specific than national security. But as you see from the structure of 142, that is indeed a precondition. 142 sub 7 on page 2797. It's a precondition to the Secretary of State doing it, but there are other matters related to operational purposes that it's very important to note. First of all, they've got to be maintained by the heads. That's a list of operational purposes. They've got to be maintained by the heads of the security and intelligence agencies, 1424. Those operational purposes have got to be approved by the Secretary of State, 1426. The precondition I've identified, 1427, then applies. And they've got then to be provided to yet more accountability and oversight bodies. In this case, the ISC, that's the Intelligence and Security Committee of Parliament, is referred to at 142 sub 8, and indeed to the very top of the office, to the Prime Minister annually. See section 142 sub 10. And of course, all of that set of requirements, which simply goes to the formulation and the maintenance of that list of operational purposes, is subject to the requirements in essence, of necessity and proportionality that exists at the stage when the warrant is being issued, both in relation to the obtaining and in relation to the selection for examination by the Secretary of State. You've got to be satisfied that both of those things are necessary and proportionate, and then have got to satisfy the Judicial Commissioner on the double lock process provided for under section 140, 2795. And the significance of that, of course, is not merely does this scheme of legislation provide for that judicial involvement at this critical stage, both in relation to acquisition and in relation to selection for examination and the safeguards that apply to that, but specifically in relation to operational purposes, it isn't enough for either the Secretary of State or the Judicial Commissioner simply to look and say, well, there we are, there's an operational purpose, I can see it on the list, I can see it in the warrant. They've got to consider whether that set or that operational purpose is indeed or does indeed conform to necessity and proportionality in relation to the particular warrant which is under consideration. So with the greatest of respect, we do not accept that all that this does is really to replicate RIPA and introduce a requirement that something should be less specific than national security or national security and serious crime.
But what's said against you is it's still a purpose, not a category. It's why, not what. So it could be as broad as combating child abuse or combating international terrorism. And what Mr. Jaffe says is that's not a category of a...
He does say that, and I'm going to disagree with him when I get there.
Yes,
You won't be surprised to hear me say. We respectfully submit that it's perfectly possible through the concept of operational purposes to do what the Strasbourg Court intends to be done, which is to provide a real and realistic form of control on the acquisition and or selection for examination. That's what it's ultimately aiming at. It's not after Boolean search terms telling everyone that Anne sits in the middle of two concepts that get linked. You couldn't possibly do that. It would be mad. You've got people who are trying to discover threats or discern the needles in the haystacks or whatever they're doing. That's not what they're after at all. They're after that degree of control which was absent from RIPA. They
want the commissioner, the
authoriser, to be able to audit,
to know what it is they're authorising is the impression I've got.
Yeah, the judicial commissioner. That's why I've just emphasised the point that I have. It goes through him. It's not him or her. He wouldn't just sit there and say, well, there's the operational purpose, that's enough. He's got to decide that that operational purpose is enough for the purpose of this warrant. And if he's not satisfied about that, then he can call for more. Or he can say, I'm not satisfied about that. It's a too high a level of generality. But I agree that that's one of the core purposes of this, and not merely him, that's the Judicial Commissioner, but also the auditing of things being done and the operation of the regime further down the line when IPCO start looking at it and doing that, fulfilling their function.
So they'd sent him an application saying, we're generally against international terrorism and a warrant would help. And he'd say, well, I'm against it too, but how is this going to help?
How is this going to help in this way?
And then they'd have to do
more specificity. Why this particular thing? And as part of the proportionality exercise, that could be done in any number of different ways. It might depend on what the warrant was doing.
Yeah.
But I come back to it. The question here we're confronting, that's why I emphasised the Christian Institute point earlier on. The question we're considering here is whether that the Divisional Court was super alive to, as one sees from repeated references to this point in their ECHR judgment. The question we're here considering is whether or not the legislation is, if you will, ex facie incompatible. This is not about the proportionality of individual warrants or how those provisions might apply. The question is it so inadequate on its face as not to conform to the requirement of in accordance with law? That's why the Divisional Court was super interested in that P argument about where the dividing line lies and being sure to be very clear about the nature of the challenge that's actually being made. Here, it's a challenge to it's an ex facie challenge, in effect, to the adequacy of the safeguarding regime set out on the face of the legislation. Just to finish with two final points just by way of example on this, which may shorten things when I get further on in the submissions. 152 is worth a mention, because 152, as you know, is titled and deals with the safeguards relating to the examination of material. And they require in terms that the selection for examination be necessary and proportionate for operational purposes, as well as containing the British Islands safeguard. And just to show you how the scheme works, in Strasbourg, as you know from Big Brother Watch, they are, or they include within the concept of law, soft law as well as hard. So they rely on ministerial statements and or codes. And so what is said in a code by way of fleshing out is relevant and is potentially helpful or not. But so far as this is concerned, the code in relation to this suite of powers that fleshes out things in considerably more detail than was the case under RIPA. You have the relevant provisions of the code, current ones for this particular power, behind tab 90 on page 4409. 4409 behind tab 90 is the 2022 code. This is the most up-to-date one. And 4409 you'll see that chapter 6, just to go back to 4406, sorry, that shows you that chapter 6 is about bulk interception warrants and contains the description that it does, but there's then a prolonged and detailed chapter on that subject which goes through to 4421, and you will see, just to pick out some points of interest, 619, a review process within the agency making the application, 620, detailed provisions on what the application for the warrant should contain, including an explanation of why examination of what is to be collected is necessary for operational purpose and a consideration of proportionality. See that from 620. 628 deals with Judicial Commissioner approval and explains all of that, fleshes that out, and explains that the duties in section 2 will also need to be considered. Jump forward a bit to 661, you get the flavour of it already, but 661 towards the end. Further detail about operational purposes under the heading Examination Safeguards above 6.58. I'm now on page 4417 and 4418. But 662 in particular might be of interest. Final sentence, operational purposes must describe a clear requirement and contain sufficient detail to satisfy the Secretary of State that intercepted content or secondary data can only be selected for examination for specific reasons. And if there's then, as 664 points out, if there's then going to be an addition of a new operational purpose, then that's a major modification that needs Secretary of State and Judicial Commissioner approval. And 671 to 674 then explain how all of that feeds into selection for examination. Basic requirement of necessity and proportionality is dealt with in 671. 673, and this is at the level of practicality and detail, the requirement for any examination to be by authorised persons receiving regular mandatory training on safeguards and the requirements of necessity and proportionality. And then 674, a requirement for a record to be kept for the purposes of subsequent examination and audit. 673, I'm sorry, 673, requirement for a record to be kept for the purpose of subsequent examination and audit, including by EPCO, outlining why access to material is necessary and proportionate for the operational purpose. So in other words, each time an analyst actually looks at the material, they've got to record why it's necessary and proportionate to do so for the particular operational purpose it is relied on, and why any collateral intrusion is proportionate. And all of those documents are open to audit, inspection, criticism if necessary, oversight by IPCO. So perhaps unsurprising at the level of detail, and to assure effectiveness of the safeguarding, why it is that the Divisional Court placed considerable reliance, and so did Strasbourg in BBW Grand Chamber, on that process of all those processes of oversight. And of course you have the IPT over the top of that. We'll have records for that purpose too. So even before you get to questions of the particular protections that might be required for LPP or confidential journalistic material, you have a series of interlocking protections that are hard baked into the scheme as a whole, both at the level of, or at the point of acquiring, and at the point of selecting for examination. So the LPP and the CJM points are additional to those basic, core and thoroughly important safeguards. And that's the background against which I then go to ground one, which principally focuses on journalistic safeguards. So that's the topic. The basic position here is that following BBW Grand Chamber, the government accepts that Part 6, Chapter 1 is incompatible with Article 10 of the ECHR. The scheme should provide and should require and will require prior approval from a court or other independent administrative body in three situations. One, when the SIAs, that's the Security and Intelligence Agencies, when the SIAs search, bulk, intercept material for the purpose of identifying a journalistic source or obtaining CJM, confidential journalistic material, or two, when it is highly probable that searches will lead to the identification of a source or the obtaining of confidential journalistic material, or three, whenever the agencies intend to retain CJM, which has been inadvertently selected for examination from bulk intercept.
Retain and further examine, or just retain?
I think it's just retain. I can't remember precisely whether it goes
I know they'll
on
have
to
looked at it once, because they'll have had to find out if it's journalistic, but if they want to go back and look at it a second time. Don't worry about that, just for my note.
I only said retain, but
Yeah.
we can easily check that out.
Just remind me, what's the actual difference between this and what's there at the moment then?
You don't have prior approval of that kind for those things.
Because what the Judicial Commissioner and the Secretary of State does isn't specific enough, because they don't know it's a journalist.
Not specific enough at that stage.
So it's drawing attention in the application of the warrant. Look, this might well cover a newspaper reporter or something, or somebody off the BBC.
That's the idea of it.
The application will highlight the journalistic risk.
Yeah, it's the selection for examination stage. And you'll recall that you were going through it. I'll probably come back to the point, but I can make it generally at this stage, just for your note. The bit of the court's judgment in BBW Grand Chamber that deals with that is that sequence of paragraphs between 442 and 450 or thereabouts, So on page 2322 of the judgment, I'll come back to it in due course, I'm sure. But it's that little section. I think when you were going through it before, one of the members of the court, I can't remember which, forgive me, said, well, so you intend to do it, it's highly probable that you're going to get it, or it pops out of the woodwork accidentally and now you're going to retain it. And that, we respectfully submit, is absolutely the correct way of analysing those paragraphs of the judgment. They'd deliberately set it up in that way. And I think maybe worth just referring briefly at this point to the supplemental bundle again at page 213, because you'll see the proposed remedial order, which by and large reflects these changes. And again, I don't want to spend terribly long on this because it illustrates this is putting remedial flesh on the bones I've just identified. And you'll see that 154, if you're on page 213 of the supplemental bundle, 154 sub 1 proposed, this is a proposed new 154, remember how it slots into the IPA. Sub 1 is on the basis that you're going after the material, as it were. That's the purpose, or one of the purposes in A, 1541A. And then 1541B is highly likely. So this is setting out the conditions on which 1542 will then apply, and 1542 then introduces the independent approval. So that's going after it, and or highly likely you need the prior approval. And then when you get into, and then you'll see what is said at 1543 about what the Investigatory Powers Commissioner has then got to do. That's effectively the outweighing test. And then 4 and 5 are dealing with the accidental pop-out, if that makes sense. And I think it's only conditioned on retention.
So this is almost like a subset of operational purposes, actually, where one of the purposes of using the criteria is the selection of intercepted content to identify confidential journalistic material. You've just got to be precise about that. It can't be subsumed under some other general operational purpose, because you'd have got prior approval, but you wouldn't have had specific approval for that thing. Targeted, pardon the phrase.
That's the purpose of the change. Yeah. That was the vice identified by the European Court, and that's what sought to be corrected. But the only reason for taking you to 213 is because I say you can see the distinction between 1 and 2 on one hand and 4 and 5 on the other. But my submission is that those faithfully reflect what was found in the in Big Brother Watch Grand Chamber. It may just be worth going back briefly, if I may, at the outset here to BBW Grand Chamber to see the nature of their analysis, because it feeds into what follows. So BBW Grand Chamber, is back at tab 56. You'll bear in mind that I keep emphasising it, but you have the point already. The context here is the consideration of Section 8.4 of RIPA. If you want Section 8.4 of RIPA, it's tab 68, page 3201. I don't invite you to turn it up now. That was the predecessor power to Part 6, Chapter 1. But the power was different in all of the respects that I've just been going through. Prior authorisation, operational purposes, interception, lots of detail in it. But the basic principle was the same. Communications were intercepted in bulk, subject to automated searches, under which the vast majority were then discarded, with only a small proportion then being indexed potentially for viewing by analysts. That was the essential context of it. And the European Court of Human Rights, unsurprisingly, as they always do, conducted a pretty close analysis of the context and the facts, so that they're important because they always set the context for their legal conclusions. You need to be a bit careful in jumping from one context to another and then assuming they're going to do the same thing. They are a very context and fact-driven court, as you are well aware. So here, what did they do? If you just look first of all at paragraphs 16 to 18 on page 2210, you'll see the two systems that they were basically describing in those paragraphs 16 to 18. And you'll see the reference to 8.4 of the RIPA legislation in 90. You see in 17 and 18 the distinction that is drawn. They're using searches using simple selectors, for example an email address, and complex queries. And then at 322, to jump forward into the judgment, you will see the start of the analysis, 2292 is the page number, page 322. And here they're dealing with the general approach, as it were, to bulk. And the thing that they're considering in this initial section of the judgment is bulk different? Do we need to do something different? Do the safeguards need to be tailored? Because lots of what had gone before had involved mere targeted information, but mere targeted warrantry and so on. So 322 to 330, they analysed the nature of the privacy concerns raised by bulk compared with targeting processes. And you have the 4 stages that Mr. Jaffe correctly took you to yesterday at 325. And then the analysis of those stages at 326, 327, 328 and 329. So it's capture, automatic selection, examination and then use effectively. The third of those being most important for obvious reasons. 330 is their conclusion that Article 8 applies across the board, even though the degree of interference or intrusion may be less. So I should have specifically highlighted at 323, you'll see the structure of 322 and 323 together. 322 is explaining why it is that safeguards are needed, but why it is also, penultimate line on page 2292, that they're pivotal yet elusive, is the way they put it. And they correctly identified the core purposes of bulk at the top of page 2293. But they are very alive to the need to strike the balances in making sure that these safeguards are both adequate for the purpose of in accordance with law, but also they are extremely alive to the idea that they are useful powers, powers of really considerable importance, and that the threats being faced by contracting states and their citizens have also proliferated, as they put it in the first sentence of 323. So there's that balance which is inherent in all of the analysis that follows. The court's Article 10 assessment, so that's their basic approach, and then they come to consider in the following paragraphs 332 and following whether they need a new kind of bespoke approach. And the answer is you do need a new bespoke approach because bulk gives rise to all sorts of different considerations. There's a great long section as to why that should be and as to how, in broad principle, that should work before they come to the specifics. At 348 on page 2299, really all the way through to 364, but the core point that is derived from that is that you need, effectively you need a bespoke set of safeguards to deal with bulk, and so that's why they then go on to consider the detail that they do thereafter. So far as Article 10 is concerned, which is what we're concerned with under this first ground, their Article 10 assessment is at paragraph 442 and following, which will be very familiar now. We've looked at it on quite a number of occasions, or you've already looked at it on quite a number of occasions, and that whole section really from 442 through to 450 needs to be read, or possibly even to the end of 458. But you'll see, just picking out a couple of points, you'll see that 443 on page 2322 draws a distinction, what it calls a fundamental difference between orders to disclose sources and the authorities carrying out searches of the journalist's home and workplace with a view to uncovering searches. It states that the latter, even if unproductive, is, as they put it, a more drastic measure, because investigators who raid a journalist's workplace have access to all the documentation held by the journalist. So that's the fundamental distinction or difference that they identify there. And you see what is said in the remainder of 444 and 445. By way of general principles, these are all under the heading of general principles. They refer to Weber at 446, where the European Court had found, as they record in 446, that the interference with the first applicant's freedom of expression could not be characterised as particularly serious in circumstances where there was strategic monitoring and where the surveillance measures, as it's put in 446, were not aimed at monitoring journalists or uncovering journalistic sources as such, not particularly serious, and so manifestly ill-founded because there were some safeguards. Then they come to the approach to be adopted in this case, and of course this is the key. 447 and 448 are the core reasoning, and we do submit that the court, in its description when my learned friends were making their submissions of what these paragraphs do and the contrast that then exists in 449 and 450, and that sequence of analysis was right. Those paragraphs 447 and 448 are founded on the assumption that where intercepted material is searched for CJM, or the search terms mean that accessing CJM is, quote, highly probable, the degree of interference is even greater than that occasioned by an order to reveal a source, because you're then closer to the in the journalist's home thing. It's an equivalent to that, so you get all the journalistic material, all of the documentation held by a journalist per 443. We saw that fundamental difference being identified there. The conclusion on intrusiveness in turn then relates back to the nature of bulk interception as analysed by the European Court, and it reflects the fact that that sort of interception involves collecting a very large amount of material and subjecting it to searches using strong selectors like an email address. Hence the finding that significant amounts of CJM would be very likely to be acquired through the use of the relevant search terms. And in such circumstances, prior independent authorisation was required. That's the reasoning in those two paragraphs. They didn't say, and they deliberately didn't say, that the prior independent authorisation was required just because CJM could be acquired or might be acquired, or even was likely to be acquired as a result of using the particular search terms. The test that was deliberately and carefully set up was one of intention or high probability. And that in turn resonates with their analysis of Weber at 446, characterising the strategic monitoring in that case as not particularly serious. So if you're directly on it and you're going after it, that's your purpose, or it's highly probable, then one set of rules applies. If not, not. And they deal specifically with bycatch, as they put it, at 449, fourth or fifth line, in 449 and 450. And the punchline of that, brackets, by way of contrast to the analysis that's preceded it in 447 and 448, is really that final sentence, long sentence at the end of 450, starting 3 lines up from the bottom of page 2324, moreover, even if, in 450. But you see the contrast there very clearly set out, and in relation to that, if it pops up, it's the bycatch, or the phraseology you want to use, and you then want to retain it, then you've got to go off, because you know it's there, you've then got to go off and get your specific authorisation. That's the way the analysis works. So that's what the European Court does in relation to bulk intercept. There's then a separate section of their judgment which deals with the acquisition of CD, that's communications data, and Article 10. That was dealing with the acquisition of CD under Part 1, Chapter 2 of RIPA, predecessor power to Part 3 of the IPA. And on that part of it, the European Court's reasoning on Article 10 is at paragraphs 517 to 528, starting on page 2338. 2338. You'll see the heading at the bottom of page 2338.
So this is part 3.
This is part 3.
Right. Or the equivalent.
Or the RIPA equivalent.
Yeah.
I'm going to take this relatively shortly because the court will see, when you read the relevant section of the judgment which deals with this, which is really from 517 through to 528, so it's about 2 pages in total. It's quite important to read the chamber judgment summary at 518 to 519 because we didn't contest the findings of the chamber, and the Grand Chamber found no ground on which to disagree with those conclusions. See 521 and 527. 521 relates to Article 8 and 527 relates to Article 10, as you see from the title above, para 523. And the core point, as you will see from the summary of the Chamber judgments in relation to either Article 8 or Article 10, is that there was a breach of EU law and because there was a breach of EU law, it followed that it wasn't in accordance with domestic law, and so it followed that it wasn't in accordance with law. The reasoning had nothing to do with what the first section of the Grand Chamber thought were any freestanding requirements of Article 10. It was simply a narrowly based finding that flowed from the fact, and indeed the concession, that the relevant provisions were inconsistent with the requirements of EU law. By that stage we were into the Watson and Davis turf. So that's the essential reasoning in relation to that part of the matter. Can I then come against that background, which I hope has helpfully reminded you of the relevant parts of the judgment in BBW, can I come to the challenges under ground 1 that are specifically made and take the various criticisms of the legal requirements of the IPA made in the claimant's skeleton? And I'm going to follow or try and track the claimant's skeleton directly, if I may, so that you have the responses that we give to the core criticisms as they're set out. And I deal first in the main of it, large part they're going to be, at least in relation to this first ground, they're going to be in paragraph 20 of the claimant skeleton. And the first of the criticisms in claimant skeleton, paragraph 20 sub 1, is that the safeguards must apply whenever the search terms or whenever search terms are used that are, quote, known to be connected to a journalist. And what we say about that is this: the context in which the European Court at paragraph 448 of Big Brother Watch, page 2323, the context in which they used and referred to search terms, quote, known to be connected to a journalist, has got to be properly understood. The court's stated intention, you don't just take phrases out of context, the court's stated intention was to ensure independent authorisation for search terms which had the intention of identifying a source or obtaining CJM, or were or would highly probably lead to that outcome. That's why in the first sentence of 448 they referred to the deliberate use of a strong selector connected to a journalist as an example of such a term. In other words, it was assumed that where a strong selector connected to a journalist was used, it would be used to obtain CJM or would be highly likely to do so. They did not consider, were not asked to consider, what the position might be where a strong selector connected to a journalist was used in circumstances where there was no intention to obtain CJM or where it was not highly likely to lead to that result.
I think Mr. Jeffrey said that difficult to think of circumstances where if you engage in that sort of activity you're not going to find something which will...
Well, there are undoubtedly some circumstances where that might occur in the context of the work of the agencies. And there may be legitimate interest in surveillance of a journalist who works on behalf of a repressive regime and is seeking to sow disinformation.
But it doesn't matter, does it? Because if it's never going to happen, it'll be caught by the highly probable anyway, because this is an attack on the legislation. If, in fact, whenever you look at a journalist, some information, and you've got something connected to a journalist, the spouse, the children, anything like that, if it's the case that it's highly probable that you're going to get access to journalistic material rather than an exchange about who's doing the shopping, then it would be caught by the amendment, wouldn't it?
Well, it may be. There may just be circumstances in which you are not, as it were, going after, and it is not highly probable that you're going to end up.
If it is highly probable, if they're right.
If it is, then
if the moment you search anything that has any connection with the journalist, it's highly probable that it's going to reveal it.
Well, my submission doesn't necessarily follow.
No, but if it did, it would be covered by the legislation.
If it did, you'd be covered by the legislation. We're having a heated agreement about that.
Yes.
But there are circumstances in which you might be, as it were, putting in search terms with no intention, and where it isn't highly probable you're going to...
Holidays in a particular country, and it turns out that the journalist went there.
Yes.
But it may turn out that his mother-in-law lived there.
Exactly so. And if you bump into it and it's bycatched, then you've got to do your retention thing.
Yeah.
So we respectfully submit it may be a bit of a non-point, but there are circumstances in which it may be that you're looking for journalist material or you're looking into journalist communications where it isn't either the purpose of it or highly probable. And one can think of any number of particular examples in which that's the case. So it doesn't automatically follow. And of course, the point of principle is if that's the right answer as a matter of practicality, there's no reason of principle why communications by a journalist should require particular protection under Article 10 simply because they relate to a journalist. And journalists can do lots of other things. They can act as agents for a foreign power. They can engage in criminal conduct.
They can be governors of schools.
They can be governors of schools. They can do all sorts of things. It doesn't necessarily follow. The one doesn't follow from the other. You have the point. We therefore submit that the Divisional Court, in their ECHR judgment, at paragraph 342 of their ECHR judgment, page 960 of the core bundle, said that the Strasbourg Court's case law, as they put it, does not state that any documentation held by a journalist is protected, and indeed such a provision would be unworkable, applying to any interchange between a journalist and anyone else at all. And that, we respectfully submit, is self-evidently right, and there is nothing in Big Brother Watch Grand Chamber subsequently that would undermine that at all. So it may be a narrow point, but there it is. That's the first criticism in the claimant skeleton. So claimant skeleton 20 sub 2 this is the likely versus highly probable versus etc. 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 It's that one, whether the test is likelihood or whether it's intention and purpose, a la remedial order in the structure that I showed you. That's the issue that's raised here. And on that front, the short answer is that highly probable, or actual purpose and intent, is the language used in 448 of BBW Grand Chamber that we've seen in the context of bulk interception, and that's the relevant test. To the extent that the word likely is dragged out of 5 to 528 of the Grand Chamber judgment, if that's the foundation of this, they do not, as I indicated when I invited you to reread them earlier on, in this context of setting, they don't set out a freestanding test for when independent authorisation is required under Article 10 at all. They do this, and they use the word to explain why the provisions of Part 1, Chapter 2 of RIPA breached Article 10, because they were not compatible with the requirements of domestic law. And they weren't compatible with the requirements of domestic law because it was conceded they weren't compatible with EU law at a point when EU law was part of domestic law. And you will note, in addition, if necessary, that 525 and 528 of BBW Grand Chamber don't concern bulk interception at all. They simply address the acquisition of CD. You can't mix them across, as it were. Particularly in circumstances where Strasbourg has gone out of its way in 448 and following to analyse what the right test should be. And indeed, it would be very surprising indeed if Article 10 set a more demanding standard for independent authorisation in the context of the acquisition of CD as compared to intercept being capable of including content. So it doesn't do anything of the kind. They just have misunderstood that position, and it misanalyses the way the Strasbourg judgment works. But we submit the key to this point is not to try and find a word in some other section of the judgment dealing with something else, but to go to where the court actually addressed the matter, which is 448 and following, 447 and following, or thereabouts. And we respectfully submit that none of the other authorities relied upon for this purpose by my learned friend Mr. Bunting actually advances matters at all. Nothing to the contrary of the analysis that I've invited the court to take from 448 and following of BBW. Nothing undermines the way in which they carefully structured the nature of the test that would apply at this stage. Nothing undermines that from Miranda or from Sonoma in the Netherlands, which you were taken to. They just don't go there. And the broader point can fairly be made, which is that the Grand Chamber in BBW, and indeed the section before it, specifically addressed over a long section of the early part of the judgment whether or not the world in which they were now having to conduct the analysis was a very different thing to the world that they'd looked at before. And they concluded it was, so they were going to take into account whatever they wanted to take into account, set the rules, for that new purpose, and they did so carefully. So we respectfully submit that whatever may be the position in relation to past case law, all you actually need to go to now, because Strasbourg took into account all the authorities it thought it needed to get to the right test in BBW Grand Chamber, all you need to go to is BBW Grand Chamber, because it is the last word at the highest level on these issues. Claimant skeleton 20.3. This is about the overriding requirement in the public interest point, and may indeed collapse, as I think my lady pointed out, into a very, very narrow point indeed about the nature potentially of the remedial order, and whether or not you need the actual words in the order on the face of the legislation. I emphasise, we accept that where independent authorisation is required, the person who carries it out would be required to assess whether there is a public interest requirement which justifies overriding a journalist's Article 10 rights. There's no dispute about that. But that's a very different thing, we submit, from saying that you need the language of overriding interest written into the statutory scheme.
Well, is that what necessity and proportionality mean?
Yeah.
That's another way of describing why you're doing it, and are you sure you're not going too far?
My lord, exactly so, and perhaps at that point as well, one's got the if there's any doubt about what necessity and proportionality means, you've got Section 6 and the various authorities that Strasbourg has promulgated in this area to help you.
When it talks about, I know we're dealing with generalities at the moment in some senses, but when it talks about independent authorisation, I mean, there are various types of authorisation that apply in other jurisdictions.
Yes, parliamentary committees and things.
In that are referred to in Big Brother Watch, and that indeed arise in the codes of practice and in the legislation in the Act. Is there any? I mean, what is the, do we have a definition of independent for this purpose? I mean, would that include somebody from a different department or anything like that?
I don't think it would.
It's simply,
I don't think it would.
simply confined to a completely independent body.
Yes, I don't. I mean, wouldn't it be lovely? I don't think I can. I don't think I can make that submission. I don't think, in answer to your direct question, I don't think I'm certainly not aware of any clear and direct definition of what independent means for that purpose. There's lots of case law on what independence means for the purpose of judiciary. Findlay and others in the UK.
We have judicial commissioners.
Judicial commissioners would be fine. But I think if you there's always been a contrast, at least in this area, between internal authorisation, which may be in a different body, a different department. I think there have been some debates about whether or not you could go to someone in the MOJ if you were part of the agencies. But I think that there's always been some considerable degree of caution about assuming that that would be independent for present purposes. So
No, I'm not making any assumptions.
no, well, I don't want to make I don't want to make a submission that creates a hostage to fortune. There isn't a clear and obvious definition for present purposes, but I think we've all been using the contrast between internal authorisation, as it's sometimes referred to in the papers, and things like JC.
But it seems to be internal to the agency or department, but also independent from the executive.
Yes.
It's got to be outside the control of the department that's doing it, but it's got to be outside the control of government, is the impression I get.
Well, that certainly looks that way from the case law, and it gets a bit blurry when you get into Scandinavian countries where parliamentary committees have some role in this, quite where they sit on the spectrum. Maybe something we don't need to address.
Well, they may not be the executive, actually.
I mean, I think the position here is that if you need authorisation that is not internal, in inverted commas, authorisation, it's either been JC or it's been whatever the acronym is, the OGCD, OCTA. That's that one. But I think that's ITCA at the top, OCTA, isn't it? Yeah. So that's Sir Brian or Sir Adrian. Sorry, I was still on the requirement for overriding. Not to spend too much time on this, is not the greatest point in the case, but overriding requirement in the public interest. We do invite you to note one thing, perhaps, in relation to this, that which is that In Goodwin, which my learned friend took you to, don't invite you to turn it up now, but tab 27, page 1026, in the authorities, at paragraph 39, page 1046, the issue was whether the High Court order to disclose a source violated the applicant's Article 10 rights, and they found that the interference was not necessary because there was no overriding requirement in the public interest justifying disclosure. See paragraph 45, 1048. They also found, see paragraph 33, they also found in their analysis that the relevant national law, which was section 10 of the Contempt of Court Act, was in accordance with the law, even though it didn't say anything about the need for overriding interest on its face. It simply provided that an order for source disclosure could only be made where it was established to the satisfaction of the court that disclosure was necessary in the interests of justice. But that was held to be good enough for the purpose of in accordance with law. So there's no express reference, but it's still held to be in accordance with law. And we respectfully submit that that's a good authority for the pretty basic proposition of principle anyway, which is that, as my Lord Justice Lewis puts it, it's really a description of what proportionality requires you to do anyway. So that's 20.3. Then there is there were a set of points around the definitions relating to confidential journalist material and the cutback that is said to have occurred and the protections afforded. They're mainly dealt with in the claimant's skeleton at paragraph 21. And just to focus on the one that was focused on in relation to all of this orally, there was a complaint that information is excluded from the definition of CJM if it is created or acquired with the intention of furthering a criminal purpose. And it said that that would exclude from the definition of CJM information provided by a source acting in bad faith or with a harmful motive. And the point that we make in response is that the statutory scheme applies journalistic protections both to CJM and to material obtained from a source of journalistic information as defined in section 263, brackets, see page 2923 for that purpose. And see also Schedule 7, paragraph 2 to the Act on page 2986, and see the Interception Code at paragraph 9.85, sorry to give you a series of references, tab 90, page 4464. So the definitions of those two categories, as it were, overlap, but they're not coextensive. A source of journalistic information is an individual who provides material intending that the recipient to use it for the purposes of journalism or knowing that it's likely to be so used. And that definition applies irrespective of whether or not the individual, the source, acts with a criminal purpose.
Can we have a look at these sections?
My lady, of course. 263, 2923.
What's the reference?
2923.
Thank you.
I've got that right. You see the source of journalistic information, that just by the second hole punch notionally on page 2923, or the lettering down.
Right.
And then the code sets out the substantive protections.
It's
for sources.
264 as well. The point was made that how does that definition work with 264? Because 2645 on 2925 is the one that Mr. Jaffrey showed us as saying material is not to be regarded as created or acquired for the purpose of journalism if it's done with the intention of furthering a criminal purpose. And something was made with the word material there, and information, although journalistic information is an individual who provides material intending the film to use it. I'm not quite sure I understand what the issue is yet, leave alone what the answer is. They seem to be saying that the definition of journalism in 264, journalistic material, excludes what's in 5A, and that they seem to be saying trumps the definition of source, I think, but I'm
That's
not
for
sure.
the purposes of this section.
Are you saying that because there's an individual definition of source, that the source remains protected?
I am.
Ah, right, yes.
I am. Whether the solution to all this, I mean, I quite understand why you're asking the question, but whether the solution to all this is said for the purposes of this section, I'm not sure, but there is a specific definition of source of journalistic information.
But I bet when we go to other sections that talk about journalistic material, that says as defined by section 264 at a guess.
Well, it might. It might. Can I see if I can find an answer to the conundrum overnight? I haven't immediately got one on my feet, I'm afraid. But I mean, we're not, as it were, trying to suggest that the source is not protected.
No, it's how it is.
It's how it is.
At the moment.
It all ties together. But I'll see if we've got any better answers on 2645.
But non-source provided information, where the journalist was intending it for the purpose of furthering a criminal purpose, that wouldn't be journalistic material.
It wouldn't.
Let's take this as an example. A journalist who also sidelines in drug dealing, his text messages with his customers and his price rates for different drugs, that wouldn't be covered.
No.
And you would say that's all right, would you?
I would.
Right, okay.
I would. And likewise, if you take out drugs and put in bomb making.
Well, whichever.
So this is designed, if I've understood it correctly, I may not have done, but if I've understood it correctly, it's designed to protect the source while striking that balance, criminality more generally. So, if one wants to make the contrast, it would cover and would protect someone who commits a criminal act by copying a government document, the kind of Edward Snowden type, but it wouldn't, as you say, cover the list of all the text to do with the journalist drug dealing, which is at least a semi-logical distinction.
Yes, and the truth is, when you've still got to protect the source, and you're going to do that overnight, and secondly, that's all right, that the convention allows the distinction and says you can't take action against the source, even if the source has been bribed or whatever, but you can take action in relation to the journalist.
Well, I'm not aware of any direct authority on that, but it would be very, very odd if you if you couldn't, as it were, get access to the journalist material if you do it.
That's an a priori thing.
It is.
Right. Okay.
That's a submission.
Yeah.
This is principally about whether you need to get the independent authority as well, isn't it? It's principally about independent authorisation. This distinction feeds into that, as it were.
Yes.
So you only need it if you're after the source. You don't.
If you're after the source, you need the authorisation. If you're after the drug list or the bomb making stuff that he's got in his cabinet, you don't need the authorisation.
Yeah, and that rather chimes with the basic idea of.
Anyway, I've understood it now. It's hard to keep a grasp on some of this. Actually.
It is, well, it's complicated, I'm afraid. We're now down into the weeds.
Well, it doesn't get much help. Speaking for myself and with respect from what's said in paragraph 352 of the Divisional Court's judgment.
Sorry, in which paragraph are they?
It's 352.
352.
I mean, I'm not sure it's worth turning up. It just deals summarily with the point.
agree. I mean, it doesn't quite go into the detail of source versus non-source. Well, that is fair enough. But if I may at least attempt to defend them a little bit, I mean, they are there dealing with the drug list idea, and the idea, I think, no doubt reflecting the arguments that were being mounted, which slightly adopt the chameleon shape at some points in this game. But it may well be that the argument was being put a bit more broadly, but we respectfully submit that there isn't any general principle that says criminal purpose doesn't matter at all ever, and in circumstances where journalists can act in a way that doesn't have anything to do with journalism, making drug lists, doing bombs, foreign espionage.
Well, I mean, the point the Divisional Court was making was a different. You're saying that the source remains protected, and we wait to see how that is arrived at. The Divisional Court was saying, well, exclusion isn't problematic in Article 10 terms. Well, that's a slightly different point.
They're accepting your a priori submission on content, I think, is what they do there.
That's the idea. I think they just haven't zoomed in on that source versus journalist. I think they're on the journalist thing rather than the source thing. As I say, I don't want to be overly critical of them, because I mean, the number of points that have been made and slightly reshaped in this litigation without any criticism of anyone.
You gave references on this point to Schedule 7 on page 2986 and to the interception code on tab 90.
Interception code with tab 90, yes.
Do we need to see anything specific?
Maybe worth just turning up the interception code, perhaps. 4464.
Yeah.
9.85.
You have to balance the journalist rights under Article 10 with, say, Article 2 and Article 3. So if it was criminal activity and bomb making or something, you'd have to take that into account too, I just think.
Well, this rather goes back into what the Divisional Court said, because I suppose it may have something to do with the breadth of the definition of journalism here.
The 985 point.
The 9.84 and 9.84 in the code. Anyway, I'll see.
Four 4464 is interesting.
Yes, at 984, yes. And then 985.
You were intending to take it we should look at
To 985.
985.
Yeah. I hadn't intended to take you to 984, but the debate's broadened, and 984 is of interest in that broader context.
And was there anything in particular in Schedule 7 you wanted us to look at?
Yes, I'm told that Schedule 7 requires protections to be provided. That's all.
Okay.
That's the only point. Not sure rather uselessly I can do much more on that point, sorry. There's at least a coherence to the distinction, at least I hope there is, based on why it is that Article 10 protects journalists. They don't protect journalists just because they've got the name journalists. If they happen to be bomb makers or spies, they protect them because they're dealing with journalism.
Thank you.
And then the suggestion is, this I think was more a Mr. Jaffe point rather than a point from Mr. Bunting, but I think they both took it. The requirements in BBW should apply to surveillance powers other than the bulk interception power. This is the washout point. Does the logic cut into the other bulk powers? And so far as that is concerned, we do respectfully rely at this point on the fact that Strasbourg is a very context and fact-driven court. There is no finding by Strasbourg that it flows outside the powers which I've been addressing, which are the interception powers, into anywhere else, or that the logic goes that far. And these are obviously important powers and important safeguards, and if they're going to be rolled out into other powers, that risks having considerable effects on the work of the agencies, with all the consequent difficulties that that might create. So the context is very, very important, and we do submit that this is a paradigm example of the sort of context in which that fully confident message resonating from the Supreme Court in AB needs to be taken very, very seriously, because if it doesn't obviously follow, if I can put it that way, from the reasoning of the Strasbourg Court that a set of safeguards does need to be applied into another context, into another set of powers, however there may be some similarities between those powers and the powers that they were considering, then the government should properly and constitutionally be allowed to test that point in Strasbourg. That's the whole point of ULA and AV, and if the domestic courts decide that isn't the answer, then we'll never know what Strasbourg would have said. So you need to be very sure that the flow out is really a correct flow out, which is required. It's almost like a necessary implication point. It's required by the logic, the necessary logic.
Well, what about chapter 3 then of part 6? Chapter 1 of part 6 is interception. It's going through the air and you take it in transmission. Chapter 3 of part 6, which is perhaps your biggest problem, is when it's on the machine before it leaves, or when it's on the machine before it gets there. It's the same information, same level of intrusion, and all you want to do is do it by a different method.
Well, my lord, no one on this side of the court is going to dispute that there are some similarities between the sort of material and indeed the level of intrusion that might flow from getting material, getting data by using the technique which is equipment interference as compared to using the technique which is intercept. And of course it is the position that there are deliberately under the domestic legislation, and we've had plenty of debate in this in relation to the EncroChat litigation in the Investigatory Powers Tribunal, where judgment was handed down yesterday or the day before, I think, by the Investigatory Powers Tribunal. On that, you will see the complication of the regime that governs storage and how storage relates to transmission, and where things might or might not be stored in the course of what you and I might regard as a call between one telephone and another. But if anything, what that context illustrates is that the subtleties and the nuances of how things actually work, how the techniques actually work, are or can be extremely important. There therefore needs to be very considerable caution between either jumping from one context to another. My Lord of Lights, I quite accept that the EI1 is the most difficult, as it were, but jumping from one context to another, or indeed, I would equally urge caution on jumping from some similarities in some circumstances. I know not whether you can live monitor on EI, but some similarities or some circumstances in which you might get the same types of information. It might be used as an alternative. Mr. Dix plainly said that in some situations, to jump from that position to assume that the thing is in pari materia.
Don't we need to understand some material difference if we're not?
Well, my Lord, the principal one, I think, is that by and large, EI is, as it's put in the perhaps rather not terribly helpfully, it's a backward-facing power. It goes at a snapshot normally of data at a particular point in time. It isn't what Strasbourg was considering in BBW, which was in effect the crocodile clip on the bearer, with a live transmission going through with the things spinning around the pipes. But it's a power which isn't exclusively, I don't put it that high, it isn't exclusively used for that, but it is a different power to the live transmission power. You don't get, as it were, a continuous feed of intelligence, or you're very unlikely to, apart from in perhaps extremely rare examples.
Well, you would if you're monitoring the send box, the
Well,
box on
Yeah, you might or you might not. Again, I don't want to go too far into the detail of how it might work.
Yeah, but I'm just thinking about my computer, my Apple Mac. I mean, if you monitored my inbox, there wouldn't be much in it, but at the end of the day, there'd be half a dozen emails. You know what I've been up to. And that's the same as if you monitored it in real time.
Well, I mean, to some extent, there are similarities. I accept that. But I do submit that there are also differences.
And you say the fact of live transmission versus access to historically stored
Was
data
important
is
to the
different.
Strasbourg analysis and may be important here. And it may be everyone's going to have this debate. You want to be having it on a fully informed basis with it going back to, I don't know, whoever to check what the facts were and how it all worked and what the extent of the differences are. But can you say that you're fully confident in principle that Strasbourg would answer those two questions the same, despite acknowledging that there are some similarities? And what you're normally doing is going for a snapshot rather than that sort of live feed.
This remind me, this is a post-Big Brother watch issue, if I can call it that. And therefore it's not one that's been focused on
Before,
and so to this extent we're looking at it afresh.
you are, but you might need to be, if there's where you're going, a bit cautious about your appellate role in those circumstances.
Well, that's what I was going to ask you.
Yeah. I mean, there may also be limits on what the admin court could do by way of a JR. Takes one all the way back to ex facie legislation versus how things work in practice. Normally that's the glory and advantage of the IPT, such as it is. As you go into the IPT, you have capacity to do closed process, well, so does the admin court to some extent. But
so what we don't have is the benefit of the Divisional Court, considering
you don't.
this on the basis of a fully argued case with evidence.
You don't. My lady, that may be the simplest answer.
So if we don't know, we just don't know enough,
You just don't know enough.
then they haven't established the appeal.
They haven't established the appeal, and if one wants to put it in those terms, you can't assume, and you can't be fully confident that Strasbourg would find that despite some overlap, some apparent similarities between the two techniques and what you might get from them, you necessarily require all the same degree of safeguarding that you get from one to the other. One thing to say in relation to intercept, which was the direct context, but I mean, if the horrors of this litigation, both in domestic courts and in Strasbourg and in Luxembourg, show anything, it's that the number of times one goes back with a semi-cited court and says, hang on a second, did you really mean that? Because if you did, there's a hell of a problem. And we do respectfully submit that for all of those reasons, there's a need for real caution in jumping from one regime to another. Now, of course, if you decide what you decide in relation to bulk intercept, then everyone can start from that place and there's a logic that flows or there isn't. But my
There are
submission is
obvious
you're not there yet.
differences, whether they're important is another question, but Chapter 2 of Part 6 is content. It is not
It's bulk,
content.
is bulk
It's communications data, which is different.
It's CD.
And Part 5, although it's said to be thematic, that's not a word in the Act, and there's a framework there, but knowing nothing about anything to do with technology, you read Chapter 1 and Chapter 3 and they look awfully alike, except you're plugging in the computer rather than putting the wire on the line. But you say,
I say it's not that
be
simple.
very careful, it's
I
not
do.
that simple, I know nothing, and I haven't got evidence of anything.
I do.
Yeah, okay.
I do. And whether you add to that the point that my lady made about the difficulty in which the appellate court finds itself, well, so be it.
Yeah.
You haven't got any guidance from the difficult, you haven't got any facts, you haven't got any underlying material on the basis of which you could be fully confident. So that's how we put that point. I wasn't going to go through, unless you want me to, the other points about bulk acquisition. They're really the ones that my lawyers identified. CD and different BPDs are different and all of that. It's really, EI, this is a point about EI or nothing, I submit. And in the 5 minutes that remain, can I just make a start on ground 2? Because I've still got a bit of ground to cover. Ground 2 is the absence of safeguards in the bulk regimes and in Part 5. And this is dealt with in the claimant skeleton between maybe appellant skeleton, I keep calling them the claimants, but you know what I mean, between paragraphs 26 and 38 is what I'm responding to. They allege 3 defects, principally, in relation to parts 5, 6 and 7 of the IPA, which it says flows from BBW Grand Chamber and us not proposing to go far enough. And our short and overarching answer is that the claimant's argument on each of those is that our answer to the claimant's argument is that each of those arguments misanalyses the effect of BBW Grand Chamber. The claimant skeleton 26 to 29 deals with no independent authorisation of categories, it's that point, categories of search terms at warrant issue. What my Lord Justice Lewis was putting to me earlier on. And the argument is based on, might be worth having it up if you want it, it's based on BBW Grand Chamber, paragraph 354, which is on page, give me 1 second, it's on page 2300. And that paragraph acknowledges that it will be, we respectfully invite you to note, it acknowledges that it would be impracticable to include individual selectors in a bulk interception warrant. And that's for obvious reason. But it says the warrant should at the least identify, very least identify the types or categories of selectors to be used. And the basic answer that we give is that Part 6, Chapter 1 of the IPA does precisely require the types or categories of selectors to be identified in the warrant. And it may be that that's why Strasbourg used that wording, as it were. It could have been perhaps a little clearer with a weather eye to the IPA that was already in. And the same is true of all other parts 5, 6 and 7. But that's exactly what is done, we submit, by the new statutory requirement, particularly for operational purposes, to be specified in the warrant and to govern the selection for examination of any material under the warrant. I went at the outset, by way of my example, through, as you will recall, section 142 and chapter 6 of the code with all its detail. And my submission, I'm not going to repeat those submissions on 142 and chapter 6 of the code, because I gave them to you at the outset. But the European Court's language we submit, types or categories of selectors, at 354, is wide. The obvious purpose of it is to ensure that the selection for examination is not at large and subject to an unconstrained discretion of an analyst, but is constrained by some limitation on what selectors can be used, which is written into the warrant. And that is exactly what the operational purposes requirement does. Its effect is to ensure that analysts can't search material simply by reference to the wide and unconstrained category of, say, national security. They've got to seek information using a search term that relates to the subject matter that has been set out in the carefully controlled and accountable, if that's the right way of describing it, list of operational purposes that have gone through all the clearance processes, heads of agencies, Secretary of State, Prime Minister, ISC.
And whether warrant has been approved ultimately in those terms by the...
Well, that's the critical second feature of this. I go back to the point I made when I was dealing with 142, which is that you don't just have the operational purposes floating in limbo, good control that they provide. You have to be satisfied. You have to have satisfied, inter alia the JC, and prior to that the Secretary of State, but inter alia the JC, that the use of those terms, as it were, works in relation to the context of the warrant itself as a whole.
Did someone tell us that the routine, either as a matter of code of practice or something, as a matter of routine, all the purposes are always specified for all searches? Someone's nodding. I think we were told it yesterday afternoon.
I think you said it could be.
The statute says it can be, and the code of practice says it often will be.
Often will be.
The words to that effect. The statute gives power, and the code of practice indicates that that may well happen in reality.
If that's right, although there's a theoretical constraint, as you've been explaining, by reference to purpose, but is the constraint is more apparent than real if you simply bung in all your purposes and can have all your selectors underneath all your purposes.
Well, you've still got to do a necessity and proportionality analysis in relation to the particular individual warrant itself. And if your conclusion as a JC was that the relevant operational purposes, if you say we've set out all of the operational purposes on which we rely here, and the JC says, well, I can't actually make a judgment about whether or not this particular warrant is good enough or it isn't, is or isn't necessary and proportionate on the back of those, then that is something that the JC can raise. So, I mean, you would hope that it's more theoretical than real, if I can turn that point back on my lord. But it isn't necessarily. There is some additional punch in that as a safeguarding regime. And I emphasise as a safeguarding regime because, as you know, go back to Christian Institute, this isn't about individual warrants and how they work. This is about whether or not the structure contains sufficient to do what Lord Sumption identified in accordance with law as doing in the P case. See the Divisional Court, that early section of the Divisional Court's judgment, which is to try and produce, it was always used to classically be Lord Bingham and Gillen or whatever it was, and said, well, what it's really designed to do is to try and provide a sufficient framework within which uncontrolled, arbitrary or abusive discretion is dealt with.
And then if
individual things arise, that's a different matter.
Yeah,
That's
if as the slight innuendo was when we were told this yesterday, it's a basis for abusive listing, then the IPT is there.
Well, the IPT is there as a check, IPCO is there as a check, but you've got the JC, the JC is the critical one for this purpose. That's why the Divisional Court placed such reliance on that as a safeguard, because you've got an independent judicial mind who's not going to be rolling over anytime soon, particularly given that in recent years their roles have been cast under quite a big spotlight, as have the oversight arrangements that the IPCO puts in place. There have been lots of cases in front of the IPT in which Mr. Jaffe has been saying, well, that won't do because they've only got 3 staff and they haven't got enough computers and all of that. So they're well aware that the devil is on their shoulder, if I can cast Mr. Jaffe finally and briefly as the devil for this purpose.
Well, that may be a convenient moment.
Probably better now, things coming off the track.
Can I just say this? As I said, obviously we know it's a strike day tomorrow. If anybody, for any reason, runs into difficulties, don't hesitate to send an email and we'll do what